people still don't understand about what happened in that courtroom. This wasn't a dramatic outburst. It wasn't a judge losing control. It was something far more unsettling. It was silence. The kind of silence that makes experienced attorneys feel their stomach drop because they know it means the rules have just changed. Judge Caldwell didn't raise his voice. He didn't slam his gavel. He didn't argue. He stopped everything. And in that pause, an entire trial collapsed. What triggered it wasn't testimony or an objection or a surprise piece of evidence from the prosecution. It was a microphone, a forgotten microphone, one that was never supposed to be live, one that picked up a conversation that no one was ever meant to hear. And once that audio reached the judge, there was no walking it back. The moment Judge Caldwell realized what he was listening to, the atmosphere in that courtroom shifted permanently. People who were there say his expression didn't change at all. No anger, no shock, just a controlled stillness that was somehow more frightening than rage. He walked back into the courtroom, took his seat, and looked directly at the defense table. That was when careers ended. He ordered the U.S. Marshals to seize the defense laptop in full view of the jury, the cameras, and the attorneys who had been confidently running that courtroom for weeks. Not later, not after a hearing, right then. The laptop was evidence now, and not just the laptop. Every electronic device the defense team had brought into that courtroom was suddenly subject to seizure. To understand why this happened, you have to understand what Judge Caldwell had been watching long before that microphone ever stayed on. This was a high-profile federal fraud trial, millions of dollars, powerful interests, reputations on the line. The kind of case where every move is calculated and every mistake is fatal. Judge Caldwell had been presiding over it for nearly 3 months, and from early on, something didn't sit right. The defense team was unusually prepared, not just competent, not just sharp, but almost predictive. Their objections landed seconds before the prosecution could finish a question. Their cross-examinations anticipated testimony with uncanny accuracy. Witnesses seemed shaken before they even took the stand. Nothing illegal on its face, nothing provable, just a growing sense that the defense always knew what was coming. Then there was the witness who changed everything. Maria Delgado, a former accountant tied directly to the alleged fraud. Her original deposition was devastating. Clear numbers, clear timelines, clear intent. It was the kind of testimony defense attorneys dread because it doesn't wobble. But 3 weeks before trial, everything changed. Her revised statement softened. Details became unclear. Documents she once authenticated were suddenly possibly misremembered. The prosecution flagged it immediately. They raised concerns with the court. Judge Caldwell listened, but concern isn't evidence and suspicion isn't proof. His hands were tied. Until that recess. Tuesday morning, 10:47 a.m., courtroom 4B. Judge Caldwell called a routine 15-minute break. The jury exited. The prosecution gathered notes. The defense team huddled at their table, speaking in low voices, assuming privacy. They were wrong. Due to what has been described as a technical failure, the defense table microphone remained live. It captured everything. The audio wasn't dramatic. That's what makes it terrifying. It was calm, controlled. A lead defense attorney confirming that a witness had changed her story, that the prosecution didn't know she'd been contacted. Another voice joined in, not clearly identified, not someone who should have been there. That voice reassured him. She's scared. She'll say what we told her to say. Just make sure the judge doesn't find out about the contact. Then came the line that changed everything. Caldwell won't know until it's too late. The audio feed is monitored as part of standard security protocol. Within a minute, the recording reached chambers. Judge Caldwell listened once. He didn't rewind it. He didn't ask questions. He stood up and walked back into that courtroom. He didn't address the jury. He didn't address the prosecution. He looked directly at the defense table and told the lead attorney to remain seated.
When the attorney tried to stand and object, Caldwell stopped him with 6 words that froze the room. "I said, remain seated." That's when the marshals moved. They didn't approach the attorneys. They approached the laptop. Evidence bags came out, gloved hands, efficient, silent. The defense attorney protested, calling it outrageous, claiming privilege. Caldwell cut him off. Privilege does not extend to evidence of ongoing criminal conduct. You know that, or you should. The jury was rushed out. The courtroom descended into controlled chaos. Phones, tablets, external drives, everything the defense team had brought with them was seized. Then Judge Caldwell suspended the trial indefinitely, ordered the defense attorneys to remain in the jurisdiction, barred them from contacting the defendant, the witnesses, or each other. Then he said the words no attorney ever wants to hear. Obstruction of justice, witness tampering, and conspiracy charges are under evaluation. Here's what most people missed. Judge Caldwell didn't act on impulse. During that recess, before anyone knew what was happening, he had already contacted the U.S. Attorney's Office. He ensured the audio was preserved with proper chain of custody. He invoked the crime-fraud exception to attorney-client privilege. By the time the marshals were bagging devices, federal investigators were already on their way. This wasn't emotion. This was execution. Defense advocacy groups immediately called it dangerous overreach. Civil liberties attorneys raised real questions. Was the recording lawful? Was the microphone supposed to be live? Did the judge have authority to seize devices without a warrant? These are not trivial issues. Legal experts are deeply divided. Some argue Caldwell acted exactly as the law allows when active criminal conduct appears in real time. Others say he crossed a line that will haunt the system for years. And here's the uncomfortable part, because they might be both right. Because if that recording truly captures witness tampering, privilege evaporates instantly. Everything becomes fair game. But if the conversation was misunderstood, if it was taken out of context, if the unidentified voice wasn't who people think it was, then an entire defense team has been publicly destroyed on a misinterpretation that cannot be undone. The situation escalated when the lead defense attorney held a press conference accusing Judge Caldwell of tyranny. Legal analysts immediately called it a catastrophic mistake. Publicly attacking a judge while under investigation deepened the crisis. Within hours, protests formed. Online rhetoric turned dangerous. Judge Caldwell's family was placed under protection. His home address circulated online. Threats followed. This wasn't just legal anymore. It was volatile. Meanwhile, investigators uncovered more troubling details. The seized audio was longer than what had been referenced publicly. Portions remained sealed. Judge Caldwell requested that the full recording be entered under seal due to sensitivity tied to national investigations. Not state, not local, national. The FBI's Public Corruption Unit took over. That alone raised eyebrows. That unit doesn't handle routine witness tampering. It handles cases with broader implications: power, influence, people who don't want their names in court records. The defense firm collapsed almost overnight. Attorneys suspended, offices emptied, phones disconnected. The defendant remains in custody, bail revoked, the trial suspended indefinitely. And then came the detail no one can explain. Voice analysis suggests the unidentified speaker on the recording may be linked to federal law enforcement. Not a witness, not an outsider, someone inside the system. Was this a judge catching corruption in real time, or was it a trap inside a trap, a setup that exposed more than anyone intended? That question hasn't been answered yet. Judge Caldwell hasn't spoken publicly since that day, not one word, which tells you everything about where control actually lies. What happens next will define careers, precedents, and possibly the boundaries of attorney-client privilege for decades. If Caldwell's actions are upheld, judges everywhere will have a roadmap for responding to real-time misconduct. If they're overturned, this case will become a warning about the dangers of acting too fast, even with good intentions. This story isn't over. It's barely begun. And when the sealed evidence finally comes into the light, it won't just change this case. It will change how every courtroom in America thinks about privacy, power, and justice. The only real question now